Supreme Court of India Union of India and others versus Shishu Pal alias Shiv Pal decided on July 23, 2024 SCC Online SC 1769 Facts of the case. The respondent was appointed on the post of a constable, GD, in the CRPF. The respondent filled up the verification role and gave a reply in the negative in response to all the questions posed in column 12 of the form. Subsequently, a letter dated December 29, 2012 was received stating inter alia that the respondent had concealed information regarding some cases registered against him on the basis of FIR under sections 147/148/149/447/332/427/504/506 of IPC and under Section 3(1) of the Uttar Pradesh Control of Gundas Act, 1970. This led to initiation of an inquiry against the respondent. High Court quashed order passed by the disciplinary authority and appellate authority, and the appellants were directed to reinstate the respondent in service with all consequential benefits along with 50% back wages. Findings of the court. The question that arises for consideration in the instant case is whether the appellants were justified in terminating the services of the respondent on the post of constable GD in the CRPF after conducting a departmental inquiry against him on receiving information that he had deliberately failed to reveal in his verification role that 2 criminal cases were pending against him. It is an admitted position that the respondent was required to furnish all the relevant factual information as required in the verification role issued by the CRPF. Warning: the furnishing of false information or suppression of any factual information in the verification role would be a disqualification and is likely to render the candidate unfit for employment under the government. The respondent herein filled up the verification role on November 30, 2011 and in response to the specific queries posed in the last 2 pages, elected to reply in the negative. The records however reveal that the respondent was arraigned as a co-accused in criminal case. He was taken into judicial custody and was granted bail by the trial court on 4 October 2011. The aforesaid sequence of events demolishes the plea taken by the respondent that he was innocent and had no knowledge of his implication in the criminal cases mentioned in the charge memo, and therefore there was no occasion for him to have concealed material facts at the time of filling up the verification rolls. The respondent was acquitted. Vide order dated October 22, 2014 does not hold any water in as much as the judgment itself notes that the prosecution had failed to prove its case beyond reasonable doubt, and for that reason it was considered appropriate to absolve the respondent and the other co-accused by giving them benefit of doubt. In other words, it was not a case of clean acquittal but a case of paucity of evidence that led to the acquittal of the respondent and the other co-accused. In any event, in our opinion, not much would turn on the subsequent acquittal of the respondent on the basis of the judgment dated 22 October 2014 for the reason that the termination of his services is not premised on the pendency of the criminal cases or their outcome, but on the failure on the part of the respondent to have truthfully disclosed in the verification roll that criminal cases were pending against him at the relevant point in time. In our opinion, the appellants have exercised their discretion as employers in a reasonable manner. Disciplinary authority pass an order terminating the services of the respondent, which order was upheld by the appellant authority for just and valid reasons. Therefore, it cannot be urged that the decision of the appellants to terminate the services of the respondent was unjustified, tainted by any malefides or arbitrariness, or too harsh. The present appeal is allowed, quashing and setting aside the impugned judgment of High Court.